A very good evening to you, ladies and gentlemen. I am happy to welcome you to the 24th webinar of Series 6 on Basics of Law, titled Law of Insurance. This is the 64th BSL webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the chairman of the Webinars and Legal Symposiums Committee and the president of BSL, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chathre Galhena, secretary of BSL, and Mr. Pasindu Silva, treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the executive committee of the BSL for all the support and guidance. For today's webinar of Law of Insurance, we have with us an esteemed panelist, Mr. Rajendra Jayasinghe. Mr. Jayasinghe was called to the bar as an attorney at law of the Supreme Court of Sri Lanka in 1997 and has over 27 years of experience as a litigation counsel, practicing predominantly in civil and commercial law. He has a diverse legal practice specializing in insurance, intellectual property, construction and engineering, banking, finance, arbitration, corporate insolvency, and company law. Mr. Jayasinghe primarily practices as a litigation counsel, but also acts in an advisory capacity for several local and international companies and conglomerates on corporate matters, including drafting commercial agreements, advising on mergers and acquisitions. He also serves as an arbitrator in several commercial disputes and is an accredited mediator of the Singapore International Mediation Center. Prior to commencing his legal practice, Mr. Jayasinghe completed the Chartered Institute of Management Accountants UK accounting exams in 1994 and worked in finance in the corporate consultancy divisions of Ernst & Young Sri Lanka. I warmly welcome Mr. Rajendra Jayasinghe, attorney at law, for today's session. To moderate today's session, we have with us Ms. Radhina De Alves. Ms. De Alves is an attorney at law of the Supreme Court of Sri Lanka with over 10 years of experience as a legal practitioner, appearing before both the original and superior courts of Sri Lanka. She holds a Bachelor of Laws honours from the University of Colombo and read for her Masters of Law at University College London. As of March 2024, Ms. De Alves is an accredited mediator of the Singapore International Mediation Institute, having received her training in Singapore by SIMI. As a legal practitioner, she specializes in the areas of arbitration law, commercial law, company law, construction law, data protection law, technology law, insurance law, and labor law. She has served as an arbitrator in institutionalized arbitrations and has also appeared as counsel in several international and local arbitrations. I also warmly welcome Ms. Radhina De Alves, attorney at law, for today's session. And without any further ado, I invite her to commence today's proceedings. Over to you.
Thank you, Isuri, for that introduction, and thank you to the Bar Association of Sri Lanka for inviting me to moderate this session. It is truly a privilege for me to moderate this session featuring Mr. Rajendra Jayasinghe, who as a senior has been tremendously influential in my own career as a litigator. Mr. Jayasinghe has a wealth of experience, and I'm sure all of you who are logged in today are going to benefit from this session on insurance law. I was having a conversation with Mr. Jayasinghe and we were structuring how we were actually going to do this session today. And just to give you a brief introduction so that you know what to expect. The first thing where we intend to do, Mr. Jayasinghe intends to sort of explain, is we're going to take you through a policy of insurance, a contract of insurance from the time of entering into the policy to negotiating what clauses would actually be needed, and then to actually making a claim. He will discuss with you what the role of a lawyer is, how you move into a resolution of disputes with regards to an insurance claim, and introduce you to the principles of insurance in general. We will then proceed to discuss accident insurance as a separate matter. And finally, in conclusion, we'll discuss how you as a lawyer can add value to your client and how you can advise your client in a way in which sets you apart from the rest, and what sort of things you can think of that will truly add value to you as a professional and assist your client in what they need to do. So without delaying any further, on the issue of insurance and law of insurance, the first thing that we find people struggling to navigate is the amount of documents that are presented to them from an insurance company. So, Mr. Jayasinghe, if I could just invite you to give a brief introduction onto the type of documents that a person can expect from what they get from an insurance company and how they would navigate their way through these documents to best assess what their client needs.
Thank you, Radhina, and also thank you, Isuri, for the introduction. Yeah, so first of all, as Radhina said, we will be looking at insurance where a person takes a policy of insurance. It's not accident insurance, but a person takes a policy of insurance or a company takes a policy of insurance for their requirements. And how, from the point of obtaining that policy of insurance to the point of making a claim and to the point of proving it in the event, unfortunate event, it goes into litigation or arbitration. Yeah. So with regard to the contract of insurance, it is contract law that is applicable. It is the law of contracts that is applicable. And there are several documents which forms the contract of insurance. The terms of the insurance policy in general is set out in something which we refer to as the policy jacket, which is which contains several pages, and that contains what the policy is, what is the liability, what are the exclusions, what are the exceptions, so on and so forth. Now, all that is set out there may not apply to you, right? That has several covers, several conditions, several exceptions, but everything may not apply to you. What is applicable out of that whole policy jacket to the relevant policy of insurance is set out in something called the schedule. Right now, policy jacket was shown on the screen. Now we are looking at a schedule. The schedule will give the number of the policy, the person, the name of the person who's insured, the period of insurance, what is that value of the insurance, which we call the sum insured, and a description of what is insured, right? And it will also include and each value. For example, in this, what you're seeing in the screen, you know, the building is valued at a particular price, the machinery and utensils are at a particular price, so on and so forth. The schedule will also give what are the covers that are included. If you just scroll down a bit to the bottom of the screen, it will give, like, for example, fire and the words there: fire and lightning, earthquake, malicious damage, and exposure. So if you're wondering from where all these covers are coming in, all these covers are set out in that policy jacket, which was shown on the screen at the start. Now, out of that, only certain covers have been obtained for this purpose of this insurance policy. Now, for example, you see malicious damage, F2. Malicious damage is set out in the schedule as well, under F2. Okay. So not everything is taken, some of them are included. So just to come back again, the policy of insurance or the contract of insurance will contain the policy jacket, the schedule. The schedule will give the specific details of the name, validity period, sum insured, what are the exact covers that are taken. That is set out in the schedule. Then you also, the proposal is also valid for the policy of insurance. Proposal is a questionnaire you fill in to obtain the policy of insurance. And then in some instances, there is something called a certificate of insurance, like in motor insurance, where you get the certificate which sets out the vehicle number and different aspects of and details of the vehicle. Then also you can see on the screen there is something called endorsements. We call it sometimes extensions as well, because the policy of insurance can be a specific policy for a specific cover. For example, it can be a fire insurance, right? But in addition to now what you're seeing on the screen is a fire policy. That is, you're covered by under this policy if there is damage caused to the property insured by fire or lightning, you're covered under the fire policy. But the endorsements or the extensions will give different covers where you can pay an additional premium and get different covers, right? It can be for malicious damage. It can be for flood, like what's happening now. It can be for burglary. So different covers, by paying an additional premium, you can obtain under the fire policy, you can obtain different covers. I'm just giving an example of a fire policy because that is on the screen. But similarly, it can be a burglary policy. It can be for if you're a contractor, it can be a contractor's all risk policy. It can be a motor policy. But under those policies, apart from the cover that is now in the fire policy, apart from damage caused to from fire, there are other covers also that you can obtain upon paying an additional premium. Those will be set out in the endorsements, and that is specified. If you take an extra cover, that is set out in the schedule. Now, if you look at the schedule, it says riot and strike, terrorism cover, third party liability. So all those additional covers will entail a separate additional premium, and that is set out in the schedule. Radhina, I think.
Yes. If I might just ask you, Mr. Jayasinghe, how would one connect the policy to the schedule, and what's the benefit? How would they read them together? If they were reading a policy and a schedule together, what is the sort of thing that they would need to look at?
Yes, so like I said, the policy jacket, for use of a better word, I'm just saying policy jacket, that is what contains all the terms, conditions, exceptions, exclusions, endorsements, everything is set out in the policy jacket. Now in a fire policy, it will say you're covered for damage caused by fire and lightning. Or it will say, however, there are certain exceptions or exclusions. So you're covered for damage, but there are certain exclusions or exceptions. Then there are other covers that are set out there. It can be says for cyber security, right? Covers for cyber attack. It can be covers for stacking some goods, right? There are so many numerous other covers that you can obtain under the fire policy. But a policy holder may not need all those covers. So they may pay that additional premium only to take, if there are, let's say, 20 additional covers that you can take, 20 additional risks that you can cover, they might choose, okay, I need only 5 of them. They pay an additional premium, and that 5 will be set out in the schedule. So if one were to interpret the contract or the policy of insurance what a person has taken, you have to look at the schedule. From the schedule, you figure out what's the name of the person who's insured. What are the items insured? We call it the property insured. What are the specific covers from that whole gamut of covers that one could take and that are described in the policy jacket? What are the specific covers that are applicable to this particular policy? What is the validity period of this policy? And what is the value of this policy? What are the warranties that are taken? The specific details are set out in the schedule. So when you're trying to connect the schedule to the policy jacket, for example, now you can see malicious damage highlighted in the schedule. There is a number which says F2. So if one wants to read what is malicious damage, you have to go back to the policy jacket. And on the screen, you can see F2, malicious damage. What is malicious damage is described in the policy jacket. And sometimes that can have separate exclusions, separate exceptions, separate extensions for malicious damage. Similarly, an interesting now much talked about thing is flood damage. right? Now the flood cover, if you look at it in the policy, there might be now flood cover F08 light malicious damage that will be described in the schedule. So if the flood cover has been taken, to interpret what flood cover is, one has to go back to the policy jacket and read this carefully and see what is a flood, how is it covered, and are there any exceptions. So to answer your question, you connect it by looking at the policy, looking at the schedule, and when the schedule refers to specific items, you go back to the policy and analyze the policy to see, okay, what is meant by this particular item in the schedule? Are there any exceptions? Are there any specific definitions? And that's how you connect it.
To just
Because
follow up on
now
that question.
you need, just to sorry, Radhika, you
No problem.
need both items to interpret that policy and to realize, to understand what is covered, what is the value of the cover, whether it is covered, and so on and so forth.
To just follow up on that question, Mr. Jaisingh, since you spoke about flood cover, and that is something that unfortunately we are talking a lot about in Sri Lanka at the moment. And I'm sure there are a lot of people looking into making flood-related claims. But we notice that the definitions sometimes in insurance aren't the regular definitions that we would find in the English language, for instance. How different are the definitions, and what specifically should a person be looking out for when they're trying to identify whether the harm that has been caused falls within the peril that the insurance has been given for?
Yeah, that's a very important question, Radhina, because as Radhina mentioned, in insurance policies, the definitions for certain items is very different to the understanding we have, which we use in our day-to-day language, right? Now, for example, let's take that flood cover. If we take that flood cover, our understanding in normal life is, for example, if water comes into our house, if the roof leaks and our house gets flooded, we would say that's a flood. And we would assume that it's covered. But in insurance, flood is defined very differently. As you could see, it says, I mean, I'm not going to read the whole thing, but the essence of it is there has to be escape of water from the normal confines of any natural or artificial water course, right? So the roof leaking, if your house gets flooded as a result of your roof leaking, that is not escape of water from the normal confines of any natural or artificial water course. So what is you have to see what is the normal confines. Before the normal confines, you have to analyze what is a natural water course, what is an artificial water course, right? So there is case law, unfortunately, subject to correction, I couldn't find in Sri Lanka any case law which defines what is a natural water course or an artificial water course for the purpose of the flood cover. But there are definitions in other jurisdictions, right? So they say it need not be water flowing, a natural water course or an artificial water course need not have water flowing 365 days of the year. But it has to have the characteristics of a stream, right? It has to have the characteristics of a stream. So an interesting case arose in Australia where there was heavy rains like what's happening to us today. In the Adelaide Hills, suddenly because of the sudden gush of rain, the excessive rains, water started flowing through different routes down the hill and houses got damaged and there were claims. And the insurance companies took up the position that no, it is not escape of water from the normal confines of a natural or artificial water course. And the courts upheld that. They said no, when excess water comes down the hills, it's not a natural or artificial water course. So that was an interesting area. But the point that I'm trying to make is insurance policies have very peculiar and very specific definitions of terms. So you have to fall within that to claim under for flood cover. Now coming back to the Sri Lankan experience, if you look at Kolonnawa, if you look at Aturugiriya, one could argue, yes, there was escape of water from the normal confines of a natural watercourse, which is the Kalani River Basin,
Right.
right? But if, for example, someone living in the Hantana Hills would say, my house got damaged because the water came down the Hantana Hills in Kandy, that may not be construed as a natural or artificial watercourse. But if someone says in Peradeniya, Gatabe, my house or the shop got damaged, then that is, I would say, definitely escape of water from the normal confines of the Mahaveli River. Right. So there are very diverse meanings. Now, if I move to the definition of burglary, right, in a policy of insurance, burglary also has a very peculiar definition there, because in our day-to-day use of it, if someone comes and takes something from a shop, we would think if we have the burglary cover, that we could claim from an insurance company. But no, under the burglary policy, there has to be sorry,
I believe
senior,
it's a forcible or violent entry or exit.
I'm missing the term. Yeah, thank you, Radhina. It has to be forcible and or violent entry or exit from the premises. So, for example, let's say someone has the key and opens the door and comes into your shop and steals something. There is no forcible and or violent entry or exit. But if someone breaks open a latch or a padlock and enters, there is forcible and or violent entry or exit. Not only entry, exit as well. So you can come in like a normal person, but you threaten the staff when there is violent exit, then that comes within the burglary policy. So the whole point that we are trying to emphasize today is there are specific peculiar meanings given in insurance policies. So you just need to read it carefully and understand whether they are covered or not.
Thank you for that very insightful discussion, Mr. Jaisingh. If I'm to understand you correctly, that would mean that even under the flood policy that we were discussing, for example, if there was an overflow of a drain outside a house, then that wouldn't be covered under a flood policy because it wouldn't constitute a natural waterway. Would that be correct?
You're spot on, Radhina, because even an artificial watercourse, that flood definition has two limbs. It says escape of water from the normal confines of a natural watercourse or an artificial watercourse, right? And the case law from other jurisdictions, from Australia, from the US, from UK, and from South Africa, define even the artificial watercourse has to have the characteristics of a river or a stream. So let's say I have a pond in my house, right? Just for vanity, I sort of have a pond in my house, and because of the rains, it overflows. That's not an artificial watercourse. So drains,
Right.
yes. The question is, if the drain overflows and water comes into your house or the shop and gets damaged, it's definitely not a flood within the meaning of the cover.
That's very interesting because a lot of people assume that just because their house or their garden was filled with water, that would constitute a flood. But it's important to note that they need to check the policy of insurance and see what the definition is, because the insurance definition can be very different to the definition of the English language or the average definition that we would understand.
Yeah, sure. Like, just to give you another example, just to understand, let's say there's heavy rains near the SSC cricket ground and water goes into the pavilion because of rain. That's not a flood.
Right.
So they cannot make a flood claim for that sort of thing.
Understood. Thank you, Mr. Jayasinghe. The next question is, when a person or when a lawyer is assisting their client in intimating a claim, what are the specific things that they would need to pay attention to? Are there any particular characteristics that they should look for? Is there any way that they should advise their clients in the first steps when a peril has occurred? What should the first steps be that they take? Is there any document that they need to refer or any process that they need to follow? And how do they really go about it? Because sometimes when a peril happens, it can be overwhelming. And then where exactly would they look to get guidance or to receive guidance on how they would go about intimating this claim in a way that would be best for their client?
Yeah. So Radhina, the thing is, everything, see, the policy of insurance is a contract. And as we lawyers know, your rights, duties, obligations, liabilities, everything is within the four corners of that document. And insurance policies are very extensive. When a claim happens, most policies generally describe the steps to be taken. So as a lawyer, you have to look at the policy of insurance. You have to see there generally is a heading which would say claims. And when a claim arises, you have to inform the insurers immediately. As you can see on the screen, as Radhina has pulled out from the policy, as soon as an incident occurs, first thing is you have to immediately inform the insurance company. Now that is an extremely, extremely important thing to do, because as Radhina says, it can be overwhelming, but you need to do it. Why? What is the logic behind that clause being there? That is because as soon as you inform, you give an opportunity to the insurance company to visit the place and to ascertain what has happened, to observe what has happened, to go through the details, to see on a first look at it, is this genuine? Is this a genuine fire? Has there been theft? If it's a motor insurance, is the driver the person that the insured claims is the driver, or have they switched the drivers because the driver was under the influence of alcohol at the time of the accident, or the driver didn't have a license? So you have to give immediate notice to the insurer. Some policies say, in addition to that, you have to inform the police. If that says, some policies might not have that clause. So if that says inform the police, you need to inform the police immediately. So as a lawyer, you have to look at the policy and inform your client, inform your insurer, inform the police immediately if that requirement is there. Then the second thing is, once you intimate the claim, you have to permit the insurers will come and inspect the place. They may appoint investigators to come and inspect the place. So you inform the client, just follow the instructions of the insurance company. If they might sometimes say, when there's a fire or a theft, they might say, don't go, let anyone go in. Of course, apart from the police. Don't let anyone else go and move the items. Just leave the place as is. So you need to leave it as is, because if you allow people to go in and sort of take away goods, just move the things here and there, that can really hamper your claim process, right? So, and then that's with regard to the intimation of the claim, Radhina. So you give immediate notice,
Yeah.
and you just follow the instructions of the insurer and ask them what to do and just comply with it.
And if I were to just also ask you a question, we know that policies of insurance and insurance contracts are policies of that the doctrine of uberrima fide, or utmost good faith, is of great importance to these insurance contracts. How important is that from the very inception of intimating a claim to even before that, even when the proposal for insurance is made, how important is it that a lawyer advises their clients to be very straightforward and very honest?
Yeah, because the whole insurance contract revolves around this concept of uberimai fide. Just in lay terms, the concept of utmost good faith. Because if you break it down, the whole principle is the insured or the client knows best. All the information, there is an assumption, is within the knowledge of the client. So it is up to the client or the insured, I'm using the word client, but it's the insured, the person who obtains the insurance policy, to disclose all material facts within the knowledge of the insured. If there is a doubt, I would always say err on the side of caution and disclose. Because sometimes what happens is there might be agents or people involved, independent people involved in promoting insurance business. When they're filling up the proposal form, that is, the proposal form is the first document, that's like an application to obtain a policy of insurance. There are certain questions, you have to be 100% truthful. So they might say sometimes, no, you don't need to include this, you don't need to include that. You can sort of dilute your answer there. They might say that. But all this will come to bite you at the time of making the claim if the insurance company realizes that you have not been truthful, right? So always, if you have, like, for example, when you're obtaining a motor policy, they might ask, have you had any previous accidents? Maybe you never went to the police, you settled it with someone else. And you might have the tendency, someone might say, no, just ignore, just say no. But say yes, because if the insurance company gets to know that later on, that will hamper your claim. But what is also important to note is the time period for which this uberimai fide applies. There's a misconception that you're obliged to disclose everything only at the time of obtaining the policy. No. Your duty of disclosure runs from the time you apply for the insurance policy up until you submit all the documents at the time of the claim. So if I were to give you an example, let's say you're 100% truthful at the time of obtaining the policy. But let's say at the time of making the claim, you don't divulge something material. Then that is also ground on which you have breached the principle of uberimai fide, and that can hamper the success of your claim. So your duty exists from the time you obtain the policy right up until you make the claim and then give all the details to the insurance company.
Right. So the natural progression from that is for the resolution of disputes in insurance. Now we know that once an insurance claim is made, not all of these claims are paid, and there are particularly sensitive issues that then arise from it when the insurance company rejects a claim or rejects the amount specifically that is claimed by an insured. Now, how would that dispute be resolved in terms of an insurance dispute? And I'd like to discuss this from both angles of where the claim is rejected in total or when it's just the amount or the quantum of the claim that's being rejected. Is there a difference? Is there any particular thing that lawyers need to be aware of? And are there any sensitivities in those two issues?
Yes. So when you talk of resolution of disputes, as I mentioned, everything stems from the contract, right? So the policy of insurance, you need to see whether that provides the manner in which the parties have agreed to resolve the dispute. Some or most insurance policies might have an arbitration clause. Some may not. in which event you need to go to court, right? Now, the arbitration clause also can be twofold, or there can be two types of arbitration clauses. One, as Radhina said, might say any dispute whatsoever, any difference whatsoever, the parties are agreeing to arbitrate, resolve by way of arbitration. So then, if the insurance company rejects liability, you can go and arbitrate on that along with the quantum of how much should be paid under the policy. Then there might be other policies where the arbitration clause might say it's only the quantum, like what's on the screen, clause number 8. If any difference shall arise as to the amount to be paid under the policy. So liability is admitted. So this can happen, for example, let's say you have a garment factory.
Right.
There is a fire claim on the garment factory. You make a claim. Insurance company looks at it and says, yes, the fire is genuine. We admit that we are liable under the policy. It does not fall within the exceptions. There are no exclusions. We are liable. We are liable. But you're claiming 100 million rupees. According to our calculation, there were stocks only worth 20 million rupees. So we are offering you 20 million to pay. Then there is a dispute as to the quantum or the amount to be paid. Liability is admitted. Then you can only arbitrate. You go to arbitration only with regard to the amount. But if liability is also not admitted, then when there is a clause where it says it's only the amount to be arbitrated, you cannot arbitrate on that. Right? So coming back to that question, you look at the policy because everything stems from the contract. If the contract provides for a dispute resolution clause or the manner in which a dispute should be resolved, you follow that. If it says arbitration, you look at it. Is it any dispute to be arbitrated where liability and quantum both can be arbitrated? Or is it only the amount to be arbitrated? You look at and then follow that. If there is nothing of that sort, then of course you go to the court.
Right. I just want, on that same note, I think it's important that we also discuss the issue of time limits. And there are particular time limits in which whether or not a claim can be intimated, but not only the intimation of a claim, but whether or not you can go to court itself. And I noticed in the previous one that we had put up there that there are several time limits in both clause number 5 and clause number 8, which is different. Now, how important are time limits in the context of an insurance contract and something that needs to be looked into before a lawyer would have a matter submitted to an arbitration panel or to court?
It's a very, very, very important area to look at, right? Because now what we normally understand is, if you look at the prescription ordinance, written contract, we have 6 years to file action. There's a time limit of 6 years from the time the cause of action arose.
Correct.
So there's a lot of misconception in insurance contracts. One could assume that you have a 6-year period from the time a claim is refused. No, because the policies have different time limits, and our courts have time and again held those time limits are valid over and above what is set out in the prescription ordinance. Now, for example, clause number 5, which is on the screen, it says, if the claim is made and rejected, and an action is not commenced within 3 months from the rejection, or in the case of an arbitration, within 3 months after the arbitrators have made their award, all benefits are forfeited. Which means, if you make a claim and the insurance company rejects your claim, you have to file action within 3 months. You can write letters appealing to the insurance company. You can write to the insurance ombudsman, all that. But that doesn't take away your obligation to file action within 3 months of that original rejection. Because this is what the parties have agreed and the courts will hold that you are liable. And there are numerous cases both in the Court of Appeal and in the Supreme Court who are saying that those contracts are valid, right? So that is one. Then the second time limit that Radhina asked was about there is a time limit for liability of the insurance company, right? Now that says there is generally a 12-month time limit. Now if you look at clause 20, that was on the screen, 21, 20 is arbitration, but 21 says time limit for company's liability. Now some policies will say, in addition to that 3 month where under the forfeiture clause, sometimes it will say the company is not liable for 12 after the expiry of 12 months from the happening of the event. So if there is a fire on the 15th of January 2025, if you don't file action or if there is no arbitration within 12 months, that is by 15th of January 2026, the company is not liable. So that's the second one that you have to comply with. So let's say, for example, one would ask, look, there is a forfeiture clause which says within 3 months of the rejection, you have to file action. Then there is a time limit clause which says within 12 months of the happening of the event, you have to file action. What are these two time limits? It's very confusing. That's a very common question someone would ask. So the 3 month, as soon as the rejection occurs, once you make a claim, there's a rejection, your time starts to run. You have to file action within 3 months if the policy says 3 months. Then the clause 21 applies. Let's say still there are negotiations going on, there is no rejection. Your time limit ends at the expiry of 12 months from the happening of the event, where there is no rejection. If there is a rejection, within 3 months of the rejection. If there is no rejection, within 12 months from the happening of the event. And our courts have held that that is valid. And even if you look at celebrated books like Veeramantri on contracts, it says, although the prescription ordinance says 6 years, parties to a contract are free to have for a shorter period or for a longer period.
Mr. Jaisingh, if I may just ask, it seems unfair that the prescription ordinance doesn't apply. Is there any particular reason that this is an exception that's allowed in insurance contracts that has also been recognized in our law by the Supreme Court?
Yes, one thing is, see, insurance companies like banks, if there is a claim, they have to disclose it as we call it a provision or provide as a liability in their balance sheet. And they have thousands of claims. Daily they get claims. So if at the end of 12 months, if these disputes are not resolved, they have to still carry it as a liability in their balance sheet. And as a result, their balance sheet can be completely lopsided or not it doesn't reflect, give a true reflection of the actual situation, right? So that can create a lot of instability in the market. So that's why internationally these clauses are not peculiar to Sri Lankan insurance companies. These are the standard clauses adopted the world over. Internationally, for a fire policy, they'll have these clauses. Internationally, for a burglary policy, they'll have these clauses. So these are policies that are, the wording is used internationally. So that's why they say, no, you file action. If it's rejected, you decide within 3 months whether you want to file action or not. If something happens within 12 months, you decide. So that way, the balance sheets and the insurer, there won't be instability in the insurance industry. That's one of the reasons.
That's very interesting because there's a common misconception that insurance companies are always looking to not pay on claims. But we've heard from you just earlier on that you have to fall within the definition because it's a contractual liability, and therefore people have to look into the contracts. And even on this aspect of the prescription ordinance not applying, it's very clear that it causes a disruption in the whole system and in the whole insurance system. And that's one of the reasons that this happens. So it's very interesting to understand that it's not a matter of insurance companies not wanting to pay out, but more particularly that they're governed by a strict set of rules that is outside of the normal language entitlement or the normal contractual entitlements, and even the statutory entitlements in terms of the prescription ordinance.
Yeah, because
Is that correct?
That is correct. Also, Radhina, what we have to understand is insurance companies play a vital role for the success of any economy, right? So if insurance companies like banks fail, and if there are no strict guidelines, and if they fail or if they fall, then it causes havoc in the whole commercial world. For example, let's say to do international trade, when you're shipping goods from Sri Lanka, let's say we are a big garment manufacturer, garment manufacturing economy. We have to ship our garments, we have to ship our cinnamon, we have to ship our tea, we have to ship our rubber to different countries. And for that you need insurance, right? And if our insurance companies fall and they go into liquidation because there are no proper guidelines, then our exporters won't be able to obtain insurance cover. Our exporters won't be able to export. So that affects. So there is a misnomer sometimes, thinking our insurance companies are only profit oriented and they don't pay their claims. They're always looking to not pay. No, they do pay, but we have to come within the policy, because like banks, if we don't protect those, if there are no strict guidelines, the whole economy can crash. I mean, they are not insurance companies are not ATM machines without a limit.
Right. Understood. Thank you, Mr. Jaisingh, for that interesting explanation. Before we move to the next section, I just want to remind all those who are watching that if you have any questions, please do include them in the question box, and then we can review it later on and have Mr. Jaisingh answer any questions that you might have. Moving on, Mr. Jaisingh, we just, as the next stage of after a claim has been intimated and it's been rejected for whatever reason, and then it has gone to the courts or to arbitration. There are two main elements in insurance law that needs to be proved, one in terms of liability and the other in terms of quantum. What would a lawyer need to look at in proving those two elements? And if you could give a brief description of how they would go about breaking down their case in the best way.
Yeah, so now, Radhina, it is an important point, right? Because as a lawyer, when you're advising your client whose claim has been rejected, to be successful in court or at an arbitration, there are two elements which are absolutely mandatory. It's not alternative, it's not either or. Both have to be, if you are to succeed, both have to be proved. So first thing is, what we mean by liability is, under the policy, did the incident that happened, the incident that occurred, is it covered by the policy of insurance? For example, I'll go back to that flood. There is a flood. Let's say your factory gets flooded, your house gets flooded. First thing that a lawyer has to look at is, look at the flood cover, interpret that flood cover, and see, is my client liable? Is the insurance company liable to pay my client under this policy? Is it a flood? Is it a burglary? Was there forcible entry? Was there violent exit, forcible exit or entry? So you have to ascertain liability. Once you
So in other words, does it fall within the definitions set out in the policy?
Exactly. And are they not excluded by the exceptions and all those other clauses? Right? That's first one. Does it fall within the liability set out in the policy? Once you prove that, then you go on to, what is my loss? So there is no point. Let's take the flood example. We all saw where a very famous garment factory was flooded. One could say, yes, there was water coming. It escaped the normal confines of the river. It got flooded. So it is covered within the policy. Liability is established. Then the second aspect is, what is the loss of the garment factory? You have to prove the numbers. You have to prove your loss. So there is no point in proving, yes, there was a flood, it is covered. You have to prove the loss as well. So as a lawyer, when you are formulating your case, you have to assist the client. First thing is, okay, get your policy, let's look at it. Look at the definition, look at the exceptions, look at everything and see under the policy, can we establish liability? How do we establish liability? For example, let's say there is a burglary. Do we have eyewitnesses? Do we have CCTV cameras? How do we prove there was violent entry? How do we prove there was forcible entry? Right? Do we have photographs of broken padlocks? Do we have photographs of broken latches to show violent entry, forcible entry? So that's the sort of evidence you need to then gather. Having established liability, then you have to look at quantum. Sit down with your client and go through how do you prove your loss. Have you got accounting records? Have you got documents? Get the accountants involved. If the accountants are unable to, if you need external proof, you have to engage them. Do you need an investigator? If it's a fire, do you need a fire specialist, a fire analyst to go and analyze and say, yes, this is a genuine fire. There was an electrical short circuit. This is covered within the policy. So you need to get that assistance to prove your loss, prove your liability, prove your quantum.
Right. Thank you for that, Mr. Jayasinghe. And what would be the role of a lawyer in sort of sitting down and sort of anticipating what needs to be done at the time of making a claim? How would a young lawyer look? What would they look into? What should they be aware of in terms of proving their claim, either when they're making a claim to the insurance company and prior to going into court? Is there a difference? Is there anything in particular that they should be aware of?
Yes, Radhina, the thing is, they have to analyze these two elements. You break it into two, liability, quantum. How do I establish liability? What is the evidence that I have? You gather all that. Then to prove the quantum, you have to sit with the client and ask them. Because sometimes the clients are very upset. Suddenly, let's say your premises get burned down. You're not in a proper frame of mind. But as lawyers, we need to guide them. You need to sort of show them the right direction and say, look, we need these details. Who can give it to us? Is it your security guard? Is it your operations manager? Or is it your factory manager, storekeeper? Who maintains these records? What are the records? So on and so forth. You have to sit and sort of get all the documents together, get all the evidence. Then, of course, as you know, you need to list it and file it within the time. But as a lawyer, there's a big role to play because the clients are lay people. They don't understand insurance. They are on the impression, okay, we got a policy of insurance. There was something that happened. Insurance company needs to pay. But as lawyers, we are professionals. So we can't take that approach. You need to go into the contract, look at the contract. If, for example, starting from the claim, you need to say, okay, look, something happened, inform the insurance company. Then employees so and so, gather the information, gather the evidence. So there is a big role for the lawyer to play there in making that claim.
Right. If I might just ask also now, with the recent floods that have occurred, the chances are that there are stock records that might have got lost, and there might be difficulty in an insured having to prove their claim. Is there anything that could have been done or that maybe should have been done prior to this, or any way in which lawyers can advise their clients on how to mitigate these losses?
Yes, Radhina, if you look at the role of a lawyer, right, it starts well before the claim arises. If they, of course, come to you after the claim arises, then as I told you, it's the liability and the quantum that you have to get evidence to prove. Now, let's say they come to you after the flood. your whole factory premises is burnt, or sorry, it's flooded. Then you have to figure out, how do I prove it? It may be all the documents are flooded. Then you have to ask the client, who are your suppliers? Who are your purchasers? Right? Who are your customers? Can we get the details that you sent to them? Or do you have a computer system? Do you store that data with an external person? Right? So maybe you can get an idea. Go to your bank, look at your bank statements, get statements from them to see how much you have deposited, how much you have paid out. So you can sort of build up that sort of information. Right?
It's kind of asking for out-of-the-box solutions for
you
things
have
that
to
may not be there.
Exactly, precisely, because as a lawyer, you have to, as an effective lawyer, I would say, you have to always think outside the box. As Radhina says, you have to look at out of the box solutions, right? But yeah, so that's the role of a lawyer when making the claim.
Right. As the next issue, because we've spoken generally about insurance, and one of the key characteristics of insurance that we see day to day is motor traffic insurance and accident insurance. And to discuss a little bit about accident insurance, and more particularly the fact that there are third-party claims that arise from that, which then means that it's outside of the normal liability in terms of contract. And how would a lawyer go about understanding a claim made on accident insurance or a problem that happens, and what are the different fields of law that applies to it?
Yeah, so the first part we discussed, as Radhina said, was about the insurance claims made by a person, or matters that arise when a person has obtained an insurance policy and that person has a claim, and that person, there is an incident occurring. Now we are moving to something called third party claims, where we are talking when we say accident, motor accidents, right? What happens when a person on the road is knocked down by a motor vehicle? How does the insurance get involved, and what happens? So one thing that a lawyer has to understand very clearly is, as the defendants, there is a driver, and if the driver is not the owner of the vehicle, then there is the owner, and there is an insurance company. So in a situation like that, right, let's say Mr. Pereira gets knocked down on the road. A is the driver, B is the owner, C is the insurance company. So in an action filed by Mr. Pereira, who's a third party, there will be 3 defendants. Now, the manner in which the 3 defendants become liable is under 3 principles of law. The driver is liable for his negligence. So it's the principles of delict that would apply. Because he has acted negligently, he has driven negligently, and he is liable under the principle of negligence, or he's made a defendant on the principle of negligence. Then the owner becomes liable, because if the owner is not the driver, owner becomes liable under the principle of vicarious liability. Right? That is master-servant relationship, or I would like to use the word the control. Owner had control over the driver at the time he moved the vehicle and met in an accident. So he is vicariously liable for the negligence of the driver. Then today's topic is insurance. Why is the insurance company liable? Because the insurance company is neither the driver, most occasions not the owner of the vehicle, but the insurance company gets lugged into a third party case. That is under the statute, that is under the Motor Traffic Act. So we call it statutory liability. Right? So that is why the 3 principles: driver for negligence, owner for vicarious liability, insurance company statutory liability under Section 105 of the Motor Traffic Act. Now, Section 105 of the Motor Traffic Act says, if there is a decree against the insured for a liability set out in Section 100, subsection 1, subsection B, the insurance company has to pay money. Right? Now, that is important. This is very important to understand, because sometimes there is a misconception that the insurance company is liable to pay a third party in a third party accident all damages that was caused to the third party. No, because the insurance company's liability arises purely under Section 105 of the Motor Traffic Act. And 105 of the Motor Traffic Act specifically says it is only to satisfy a decree issued for a liability under 100 subsection 1 subsection B. So if you cross-refer section 100 subsection 1 subsection B, it is only for damage caused due to death or bodily injury to a third party. So Radhina, if for example, there is property damage, let's say I am driving my vehicle, I go and knock onto the wall of my neighbor, then my neighbor can't file action against my insurance company, because the neighbor doesn't have a contract with my insurance company. There is no negligence on my insurance company. My insurance company is not vicariously liable for my acts. And Section 105 of the Motor Traffic Act limits only for death or bodily injury. But I've seen numerous claims filed by third parties for property damage where they have made the insurance company a party and they have given 106 notice on the assumption that the insurance company is liable for everything. So just remember, the insurer, you have to make the insurance company a party under 105 only if there is death or bodily injury to a third party. Otherwise,
If I may just ask,
liable.
sorry, if I may just ask you, Mr. Jaisingh, now something that regularly happens is when two vehicles meet with an accident, and say I crash into your car and it's my fault, then can I claim from your insurance company for the damage that has been caused to my vehicle?
No. If we go to that example that I gave, you have no contract with my insurance company. My insurance company is not vicariously liable for my driving.
Right.
So the only way you can, my insurance company becomes liable to a third party is only under Section 105, which cross-refers to Section 101B of the Motor Traffic Act, which is death or bodily injury. So yes, your question is a good question, because most often we think if we go and knock on someone else's vehicle, we can claim directly from their insurer. No, we cannot do that.
And so then the solution would be, if I'm to understand you correctly, that I would make a claim against you, and then when a decree is entered against you, when you are found to be at fault, then you could claim and tell your insurance company to pay that out. Is that how it would work?
Property damage, yes. Because the policy sometimes, the schedule of the policy might say third party death or bodily injury, you can't put a limit. So it is unlimited. But for property damage, they might put a limit. So sometimes I've seen cases where people ask, okay, but the policy says property damage is 500,000. So why can't a third party enforce that? No, you cannot, because you have to go to the basic principles of contract.
Right.
And negligence.
Understood. Thank you, Mr. Jaisingh. And in terms of proving a claim in a motor traffic accident, is it different to proving a claim under the general law of insurance, or would it be the same? It's still quantum and liability, but are there any sort of different characteristics that a lawyer should look out for when advising their client?
You're right. It is both quantum and liability again. So liability, you have to show that the driver was negligent. The lawyer has to prove that the driver was negligent. The lawyer has to prove, if the owner is different, that there is vicarious liability. So in proving negligence, a lawyer can look at the police statement of the driver, the sketch prepared by the police, then observation notes of the police, were there any eyewitnesses, then was there a magistrate court case, what was the outcome of that magistrate court case against the driver, has he pleaded guilty to negligence, or is there a finding of negligence? And all that is relevant to establish negligence of the driver in the district court case for damages. Then that alone is not sufficient to win your case. You have to prove what is the loss that was caused to me as a result of this accident. The third party has to prove it. So maybe if there is injury, I lost my job. There are permanent disabilities, right? I had to, my leg was amputated. I was 25 years old. I was in university. Or I was 35 years old. I had 2 young children. I was doing job X, which I could have earned so much. So all that proof under different heads, a lawyer has to prove when you're proving quantum. Right? But in accident, just to say something else, Radhina, under the liability of the insurance company under section 105, a lawyer also has to be very conscious to send a notice, what we call a section 106 notice to the insurance company. That is section 106 of the Motor Traffic Act says, before or within, I think it's 7 days of the action, you have to send a notice under section 106 to the insurance company, giving the particulars there. That is the name of the driver, the name of the plaintiff, name of the defendants, copy of the plaint, what is the date of the action, so on and so forth. You have to send it and make the insurance company a party. Otherwise, even if you win the case, the insurance company won't be liable to satisfy the decree. And then there are certain exceptions for the insurance company. That is, if there's a breach of if there are breach of conditions which are set out in section 102, then the insurance company has to file an action called a declaration of non-liability in another court. And then once you get that, the insurance company is not liable to pay the third party if you get a declaration. So there are certain exceptions there as well. So a lawyer, if a client comes, let's say a client who is injured by an accident comes to you to file action, you need to give that 106 notice to the insurance company. You need to send those letters of demand. You need to plead about how the liability arose. You have to plead about the negligence. You have to plead about vicarious liability. And then you have to ensure that the insurance company can't get out of it by falling within the exceptions of 107 to 109.
Thank you, Mr. Jayasinghe. We spoke a bit about what a lawyer can do in terms of when a client comes to him after an accident, or even in the instance spoken before about where a peril has occurred. And we know that there are certain things that we should do as lawyers that might maybe set us apart. And one of the key characteristics is that we help our clients navigate the situation without a problem. But in addition to that, one thing that I think most clients look out for is a quick resolution of disputes, and how we can actually resolve disputes for them in a seamless way. One of the things that has been spoken about very frequently in the recent past is mediation, and whether or not, and it's something that is picking up in Sri Lanka at the moment. What is your opinion in terms of whether insurance cases can actually be successfully mediated? And what would be the benefit of lawyers actually suggesting mediation to their clients and going forward with that process?
I think that's a very pertinent area because a lot of clients want, as you say, quick resolutions to disputes. And you know how long a court case takes. You know an arbitration can take a bit of time and it can be very costly. But mediation is a successful tool, because I know in Singapore and other countries, there's lots of insurance mediation where it's a win-win for it's a win for the client, it's a win for the insurance company. And with the mediation bill that might become the act one of these days or in the near future, I think lawyers can assist their clients by discussing with the insurance companies and trying to, when a claim arises, to try and see whether they could mediate or whether they can go into a proper mediation and try and resolve the dispute, because it's very less costly. And sometimes within a couple of hours or within a day, the dispute is resolved. And I think, Radhina, you have more experience in that than than me, and you can sort of tell something about it, how it's done.
What we have noticed most often than not is that most clients do come forward asking whether there can be a negotiated settlement of disputes, and they want to resolve the disputes without protracted litigation involved. And in those instances, I've had clients come and suggest whether they can go into mediation. So I definitely think that there is scope for mediation. And I found that in most instances, as a lawyer, when you are able to resolve disputes for your client in a swift and an efficient manner with less hassle to them, because they don't want to be involved in protracted litigation in the court system or in arbitrations for an extended period of time, that when you are a lawyer who gives them quick solutions, they in turn come back to you when there are disputes. Because I think there is also within lawyers misconception that if you resolve disputes quickly, you will lose out on cases, and then you won't have your means of income, so to speak. But I think that's a complete misconception, because the more people see quick justice and quick solutions being given, efficient solutions that they can really come back, that can really back themselves up, then they are more likely to come forward and resolve disputes. We see a lot of out-of-court settlements happening among lawyers themselves or even among clients because they don't want to get into litigation. So I personally do believe that mediation, and insurance mediation in particular, is a good way to go forward. But do you have any further thoughts on that, Mr. Jayasinghe, or?
No, I think it's good if lawyers can, although there is no mediation clause in the contract of insurance, they can approach, but it's a win-win situation even for the insurance company. If the matter gets settled, it's a win-win for the insurance company and both the lawyers as well. The client as well. Yeah.
I think we have gone slightly over the time that was allocated for the discussion, and we do have a couple of questions that have come in. Participants, this is just a reminder for you to post any further questions that you might have. But interestingly, two of the questions that have come in are with regards to the flood insurance cover that was discussed. And there's a particular question regarding whether the overflow of the Tissavaava, which constitutes an artificial lake, would amount to a flood under the insurance policy. But while this is something that maybe we can't give a particular answer for, maybe a discussion of what could be looked into in assessing whether or not there is a claim under that policy. If I could invite you, Mr. Jayasinghe, to just respond to that.
Yeah, it's a good question. Radhina, is there any way you can pull up the flood definition?
Yes, I can. So just bear with me a moment.
Yes, there, you got it. That's it. So if you look at it, it says the escape of water from the normal confines of any natural or artificial watercourse, lake, reservoir, canal or dam, but excluding destruction or damage by bursting or overflowing of water tanks, apparatus or pipes. It's good enough to confuse anybody. So yes, your question, if you look at Tissavaava, in Anuradhapura, I'm assuming, or Tissavaava in Tissamaharama, either of the two. If there is an overflow of water, it's covered because the lake is covered, right? But the counter argument, I mean, as lawyers, there will be a counter argument. If, for example, let's say there is a bursting of a water tank, I would say the water tank is there. It's not a reference to the lake. It's those overhead tanks or one of those smaller tanks, not a lake like Tisaveva. But one might say no. That's why law is interesting. One might say no, the bursting of the Mavillaru tank is a bursting of a water tank, and it's not a flood. But one might say no, but a lake is covered. The Mavillaru tank is not a water tank, but it's a lake. So we will have to, basically go into it in detail. But on a cursory glance, I would say yes, the water has escaped from the normal confines of the Tisaveva, which is a lake, and that it is covered. But as I said, there will be a counter argument to it always.
We have another interesting question that has been posed, which is in terms of the insurance companies when they issue a policy for motor insurance, that they give the insured a grace period of 2 to 3 months in which to pay the premium. During that time, in the event that there is an accident that occurs, a motor vehicle accident that occurs, and the insured subsequently does not pay the premium, which results in the insurance company canceling the insurance, how is the third-party claim to be addressed?
So the third party claim, if you break down that question, they have got a grace period, but they have not paid the grace period.
They've not paid the premium.
Not paid within the premium within the grace period.
Within the grace period.
And the accident occurs subsequently.
The accident occurs within the grace period, and because the accident occurred, they don't pay the premium, and the insurance company cancels the insurance. Then what is the position of the third-party claim?
Okay. So the first point that you have to remember is if you go step by step, once you give a grace period to pay the premium, if something occurs within that grace period, the policy is live and effective. Okay. So the insurance company is liable. But as soon as it happens, the insurance company can tell the insured, call for the money. You pay the premium because that is the consideration. Insurance policy is valid and live, but you need now pay the premium. So you need to pay the premium. If you don't pay the premium, the policy is cancelled. And the insurance company is not liable. Now that is the relationship between the insurer and the insured. Now what is the role or what is the plight of the poor third party? Now the third party, as far as the third party is concerned, their rights emanate from 105 of the Motor Traffic Act, right? 105 of the Motor Traffic Act says if there is a decree against the insured for a liability set out in 101B, the insurance company is liable. So the accident occurred during the policy during the period when the policy was valid. Then I would say the third party is entitled to claim. The insurance company is liable to pay the third party because the policy is valid. If subsequently the policy is cancelled for non-payment of the premium, the insurance company can sue the insured. The insurance company can sue the insured and say, look, we have to pay them under our statutory liability, but we are not liable because you never paid us the premium, so indemnify us for this. So it's a very, very good question, but that's how you need to do it. And as lawyers, I just want to tell you, that is why law is interesting. There are, so many complications, but as a lawyer, always try to break it down to manageable portions. Then it's easy to answer. Otherwise, if we also sort of try to look at it overall and get confused in the details, you can easily miss it.
On that note, I remember when I was a very junior lawyer, Mr. Jayasinghe telling me to break things down and take it back to first principles and see how people are liable and what are the issues and the complications that need to be addressed, which is a really efficient and good way to break down a problem and to address it as a solution. We have one further question in terms of looking into policies and looking into the warranties that have been given, and if there's a breach of a warranty, if there is any way in which that can, is there any way in which a lawyer can assist an insured who has actually breached a particular warranty? Or is there any defenses that could be taken in that regard?
Yes, because initially the thinking was if there is a breach of warranty, the whole policy can get cancelled, right? But in other jurisdictions, now there is developing case law to say there can be a breach of warranty, but what is the materiality of it to the claim in it? Let's say, for example, there is a fire claim under the fire policy. I have a factory, there is a fire. Now, there is a warranty, there is always a warranty in a fire policy that you will maintain the fire extinguishers in working order.
Right.
If there is a breach of that warranty, that is directly material to the claim in issue. So if you have not got the fire, if you have not maintained the fire extinguishers in serviceable status, there is a breach of warranty and the policy will get cancelled. So as a lawyer, look and see whether that is material to the claim, just to answer the question. For example, if there is a warranty saying that the door will be locked or all the valuables will be put in a safe, that may not be, and you breach the warranty, that may not be, and the safe does not get damaged, the claim from the fire is not for the safe, then there is no materiality to the claim. So always when you see the warranty, look at the materiality. Look at the materiality. Always, even Uberima FID visa, it has to be material non-disclosure. What is material in Uberima FID? Does it affect the decision of the insurer? If the insurer knew these details which were hidden, would it have changed the decision? That is the test of materiality when it comes to insurance. Also, Radhina, if there are no other questions, I just want to tell something else to the lawyers here.
Yes,
So
please proceed.
as lawyers, I mean, this is not only in insurance, in everyday advice, but related to insurance. As lawyers, we have to add value to clients. If we are only there as lawyers, where the client where we are going to tell them, no, according to this act you can do, according to this section you can't do, you're not adding value to. They can go to any lawyer and now they can refer to any AI tool and get that information. But as a lawyer, we have to add value. Why do I say that, and what can we do pertaining to insurance? Let's say you're a lawyer working in the legal division of a company, of a manufacturing company. When the policy of insurance is there, when they're obtaining an insurance policy, this is the role, the whole through the whole gamut of it, this is the role that you can play. You understand the business. You go and understand the risks. What are the risks that could happen? Is it a fire risk? Is it a flood risk? If you are exporting, what are the risks that my business can happen to the business, and how do I insure it? Then talk to your insurance agents, talk to the insurance specialists and say, these are the risks. How do I insure my company against those risks? Advise the company accordingly. Then once you get the policy, study the policy. What are the exceptions? What are the warranties? For example, in the fire claim, if there is a fire policy, there may be a warranty. You have to maintain the fire extinguishers. If it's a warehouse policy, it will say how the gap between those racks, how do you store them? There is a stacking warranty. So as a lawyer, you would study that and advise the relevant people. Look, if you don't do this, this is what can happen. So please ensure that these things are complied with. Then when a claim is made, or when a claim is, before the claim arises, go through it and see if something happens, where do we keep the documents? Are we having supporting documents? If our place gets flooded, do we maintain copies somewhere else? Should we maintain copies somewhere else? Should we keep it online or should it be physical? Then when the claim arises, we have to inform someone immediately. You can't be looking at policies at that stage. if your managing director calls you as head of legal and says, look, there is a fire, what do we do? You should be able to say, look, you have to make a claim. I have already told the head of operations that he is the person to make the claim. He is the person who has to go and make the police complaint. He is the person who has to, we have to appoint external investigators. So be proactive. Then what are the details we require? You have a list and advise the company, look, to prove the quantum, this is what we need. To prove the liability, this is what we need. Sit with your finance department and say, okay, how do we prove the losses? How do we prove our purchases? How do we prove, do you have the resources? Do we need to get external accountants? Do we need loss adjusters? Do we need fire specialists coming in? So that is the role a lawyer can play. Because a lawyer has to add value and navigate your company in the least amount of disruption to get your claims sorted out. And if you are in doubt, speak to your insurance company. If you need to disclose certain things, for example, you have a factory, you are storing petrol for your generator. Please inform the insurance company before the fire. Before something happens, look, we have a generator, we are storing petrol. Are we okay? Do we need to store it somewhere else? Are you comfortable? Because after the fire, then the insurance company can't come and say, no, there was petrol, you have not stored it properly. So always look at ways of adding value and how a lawyer can assist your company. Yeah, so that's one aspect I want to tell Radhina.
Thank you so much, Mr. Jayasinghe. We have no further questions, and I believe we have come to the end of our time for this evening. As always, a discussion with Mr. Jayasinghe is both informative and practical, and he's ever willing to give part of his expertise and his knowledge and his little tips and tricks of the trade to assist young lawyers, particularly in strategizing their case and in doing the best they can for their clients. So thank you, sir, for your time. And thank you to each and everyone today who participated in this discussion. Wherever you are, we hope that you are safe and that you are well. And the BSL has many programs to assist with relief if any of you have been affected by the flood. So do please reach out. And we wish you a very good evening. Now over to Isuri for the final concluding remarks.
Thank you, Radhina.
Thank you. This brings us to the end of the 24th webinar of the series on Basics of Law, titled Law of Insurance. I thank our esteemed panelist, Mr. Rajendra Jayasinghe, Attorney at Law, and our moderator, Ms. Radhina T. Alves, Attorney at Law, for the fruitful and educational as well as timely discussion, and for dedicating your time to be here with us and sharing your insights. I also thank the BSL Webinars and Legal Symposiums Committee once again for their dedication and hard work in organizing this webinar. I also extend my thanks to all the participants who have joined in for this session today. Thank you, and I hope you all have a very good night.